Some of you may be aware of this already, but my name is Thomas Aquinas. I have been asked numerous times if I was named after Aquinas College, and I find it funny that some people jump to that conclusion, presumably because it's the only other time they've come across the name Aquinas. The truth is, Aquinas College and myself were both named after St. Thomas Aquinas, who was a 13th century Dominican, who in my humble opinion was the greatest theologian and philosopher ever to have walked the earth. When he was young, in a true twist of irony, he was nicknamed the Dumb Ox. In response to this nickname, St. Thomas's teacher, whom I'm also blessed to share a namesake, St. Albert the Great, said, "You call him a dumb ox, I tell you this dumb ox shall bellow so loud that his bellowings will fill the world." With this context in mind, I know my bellowings today will not fill the world, but I do hope they at least are heard in this chamber. When I look to the legislation before us today in House Bill 5207, I cannot help but see the complete contradiction between the teachings of St. Thomas and what this law will do. St. Thomas provided vast works uniting faith and reason, unlike anything ever seen before or since. He took what we encounter and experience in the physically real and connected it with the mysterious and the metaphysical. I will disclose right off, I am not an academic, either in theology or philosophy. But I do have a duty as a lawmaker to vote my conscience, uphold the truth and what I believe to be the best for our society and our state as a whole. That is the lens through which I will explain my opposition. I give this explanation in a spirit of compassion, not malice or judgment. I know this is a deeply sensitive topic that touches many people very closely. That being said, I feel it necessary to point out the dangers, flaws, and inconsistencies of this legislation and why it would be a mistake for Michigan. The alleged problem with our current state law, as put by the Democrats and supporters of this legislation, is that it is out of date. Our law already allows surrogacy, but supporters of the changes before us today say our law is inconvenient because people would have to go through an adoption process after the child is born. I would counter that while certainly this process takes time, paperwork, and expense, it is necessary to help maintain a clear establishment of a parent-child relationship in our society. The bigger issue is that the proposal before us today does much, much more than what supporters claim that it does. What it really does is put vulnerable women at risk of exploitation, treat surrogates and the babies they carry as commercial products, and fundamentally redefines the family, to the extent that family is even considered relevant at all. These bills create whole new paths to parenthood for virtually anyone else. It doesn't even matter what their relationship is, if they have one at all. Effectively, the order of the child-parent relationship that has existed since the dawn of mankind is rewritten. The most common scenario that comes to mind for surrogacy is when a husband and wife, after trying every natural path available, unfortunately and heartbreakingly find they cannot become pregnant or bring a child to term. This is a very sad situation where two loving parents desperately desire to grow their families but find themselves unable. In this situation, the woman and the man may go through a process of having embryos created in a lab and having a different woman carry the child to term. This is what most people think of surrogacy, and this is the situation Democrats often use to appeal to emotions when talking about this legislation. If this bill was limited to commercial surrogacy to a married couple who cannot naturally conceive a child, then this would be an entirely different discussion. But with this proposal today, the situation I just described of a husband and wife, that situation most people first think of will be the overwhelming minority of circumstances in which commercial surrogacy will be utilized. The overwhelming majority of cases will be any other unlimited number of circumstances I could even begin to try to predict. Let me go through this proposal and shed some light on what the real impacts of this bill will be. This bill creates an act called the Assisted Reproduction and Surrogacy Parentage Act, while at the same time it repeals the Surrogacy Parenting Act. Our current law allows surrogacy, but expressly states some prohibitions. The first aspect is the prohibition of a minor or developmentally disabled person from being a surrogate. And the second aspect prohibited is a surrogate earning compensation. Our current law also establishes a criminal penalty for entering into or assisting in the surrogacy contract and establishes a presumption that a woman carrying the child is the mother in case of dispute while a circuit court adjudicates the case. The proposal before us today has three key parts. The first part deals with general provisions. It begins by stating that the act does not apply to a child conceived through sexual intercourse. These new laws apply to children born of assisted reproduction. It goes on to define terms: assisted reproduction, child donor, genetic surrogate, gestational surrogate, intended parent, medical evaluation, mental health consultation, mental health professional, physician, surrogacy agreement, and surrogate. One of these terms in particular is worth highlighting: intended parent. To have intent suggests a probability that something may happen or is desired to happen. This term is not fitting in this legislation because there is no doubt who the parents will be, because it is established and written in a contract ahead of time. We do already have a term in our lexicon, and I find it curious that it was not applied in this context. It is the term adoptive parent, which is extremely more fitting for all intents and purposes, both by definition and what is used in the common English language. Unfortunately, in recent years, policymakers of this state have squashed attempts to promote adoption while instead prioritizing abortion. Maybe that explains the aversion to the term adoptive parent. I very much wish the legislation would do more to promote adoption for children in need of good homes instead of proposals like the one before us today. Part 1 of the bill then goes on to create a new process for assigning a parent-child relationship. If the child is conceived through assisted reproduction, then a parental right will exist for the mother, or as the Democrats sterilely describe, the individual that gives birth, and another parent as laid out in Part 2 of this act, which I will get to. Also, if a child is conceived through surrogacy, the rights of the parent or parents is established in Part 3 of the act, which again I will get to. It also makes clear that a so-called donor is not a parent. From there, it establishes a venue for judicial proceedings. If a person involved in a surrogacy contract wishes to challenge who the parents are of a child in court, this bill makes expressly clear that genetic testing cannot be used. This is a complete 180-degree turn from what is in current statute, and it is also contrary to reason. Next comes Part 2 of the Act, which deals with the circumstances involving so-called assisted reproduction. This is not surrogacy, because the pregnant woman in this case will be the rightful parent of the child she is carrying. It establishes a process for the woman, or again, as the Democrats sterilely describe, the individual who gives birth, to enter into a written agreement that another individual will be the parent as well. I cannot determine the need for this new form of parentage agreement because, for example, if the two individuals were married, then they would already both have parental rights to the child. This provision seems wholly aimed at providing a path to joint parentage outside of marriage. Certainly, it could be applied to an unmarried couple that has an established household and a relationship, but the way this bill is written, it could possibly extend to any infinite number of irregular situations. Siblings, cousins, roommates, pen pals, Facebook friends, business associates who join forces to create a baby for whatever reason under this new commercialized industry. In this legislation, there are no restrictions limiting the number of intended parents to just 2 people. There's nothing to prevent a situation where an unborn child or unborn children are genetically selected based on the most desirable traits and being marketed like a commercial product. This section further clarifies that a person does not necessarily have to sign a written document beforehand to claim parentage. A person can claim parentage if, quote, for the first 2 years of the child's life, including any period of temporary absence, resided in the same household with the child and openly held that child out as the individual child. It from there lays out a process to challenge parental disputes in court. The second provision here will open Pandora's box to any infinite number of bizarre circumstances that will inevitably arise, nearly all of which would be avoided if the parent, the one not carrying the child, were in fact married to the pregnant woman. What could go wrong? Here are a few scenarios, all of which show that the best interests of the child were an afterthought in this proposed legislation. So maybe after a woman conceives, the man or woman not carrying the child may up and leave and dispute their involvement in the arrangement in the first place. At least a single mom who conceives naturally can seek child support. Under this new process, a woman would have the monumental task of first providing or proving the other individual desired to be a parent. The chaos could also arise in reverse. A woman could claim another individual desired to be a parent and could take the case to court and establish parentage with the other person. Maybe this couple did in fact have an intimate relationship, but the other individual did not intend to be a parent. Maybe they agreed to stick around and help out, but had no commitments. This other person can end up being stuck paying court-ordered child support and being a legal parent to a child in which they have neither biological or even emotional attachment. Would a couple of Facebook pictures showing holding a baby out and records of living in the same residence be enough to force someone to be legally considered to be a parent? According to the language offered here, it's at least possible. There are many reasons people get married, and avoiding this confusion about parental custody is most definitely one of them. This is why it has been historically required for these relationships to be made public and documented. This new process outlined today throws caution to the wind and is a radical departure from reason. It will lead to very complicated situations, none of which are in the best interests of children. Now we move on to Part 3 of the Act, which deals with surrogacy. In these cases, the woman carrying the child to term will have no parental rights to the child. It establishes a process where a woman can be a surrogate, which is defined as an individual who is not an intended parent and agrees to become pregnant through assisted reproduction under a surrogacy agreement. To become a surrogate, a woman must be 21 years old, have previously given birth to at least one child, have completed a medical evaluation, have completed a mental health consultation, and have an attorney of their choice paid for by the intended parents. To be an eligible intended parent, one is to be 21 years or older and have a mental health consultation and to have an attorney. The conditions needed to become a parent are startlingly light, as evidenced by the previous amendments that were voted down by the Democrats. What is the reasoning behind the surrogate already having to have had at least one child? Why are we limiting the surrogate pool in this particular way? Is it to prey on desperate, financially struggling young families that would turn their households upside down for much needed money? Is it to prey on single mothers who may be in financial trouble? This provision appears carefully crafted to target and exploit, and it is a good example of why commercial surrogacy has raised human trafficking concerns in many nations. From there, the terms are laid out to what must be in a surrogacy contract. These terms are: at least one person must reside in Michigan. The birth of a child, at a minimum, needs to be anticipated to happen in Michigan. The intended parents or parent, the surrogate and the surrogate spouse, if any, must be parties to the agreement. As mentioned earlier, the surrogate must have an attorney paid for by the intended parents, and the agreement must be completed prior to pregnancy. It is odd and logically inconsistent with the progressive left's ideology to include a requirement for the surrogate spouse, if any, to sign on to a surrogacy agreement to make it valid. What happened to my body, my choice? Why would a spouse have a veto over what a woman does with her body? Could it be possibly because this paid surrogacy agreement is so far out of line with the natural order of things, even the progressive left realizes a woman becoming pregnant without knowledge and consent of her spouse would be wrong and undercut the husband and wife relationship. After establishing certain requirements for surrogacy agreements with a shocking lack of common sense safeguard, this act wraps up by attempting to address disputes or other circumstances that will inevitably arise, like the unexpected death of an intended parent, a laboratory error where there's a mix-up and the child is not of the genetic origin of what it was intended, or even an improperly drafted or executed agreement. Much of this gives the circuit court judge the discretion to try to sort out the situation and impose a solution. In one circumstance, in Section 308 of this bill, the judge's hands seem quite tied. If the surrogate claims that the child is in fact hers and not the intended parent's, the judge is to declare the intended parent or parents to have parental rights of the child. This gets confusing because Section 306 of the bill says genetic testing is to be used if parentage is contested by the surrogate. But Sections 108 and 308, as well as House Bills 5212 and 5215, prohibit the use of genetic testing to determine parentage of a child born under a surrogacy contract. While this language of this proposal is sloppy, I have to conclude it's both the legislative intent and the interpretation of a judge will be to prohibit genetic testing to determine who is the real parent of a child born under the surrogacy contract. Why is this important? Because it is very possible a surrogate could have sexual intercourse in the same fertility window as the assisted reproduction, and she could very well become pregnant naturally. To think this will not happen is to be very blind to reality. Why else is it necessary to include this language in the first place? Why does the surrogate spouse need to sign on to the surrogacy agreement and submit to the terms and conditions? It is so the surrogate does not breach the contract and unintentionally bring forth a different child. The part that is truly perplexing to me is why this language is so tilted for benefiting the intended parents rather than the woman carrying the child. One would think that the just thing to do when there's a dispute of parentage, at a minimum, would be to structure an objective and fair way to get to the truth. But for some reason I cannot wrap my head around, the child goes to the intended parents no matter what. This is wholly unjust and a massive departure of what is in the best interests of the child. It is also worth considering how this bill will interact with future technological advancements. What will happen when technology allows for a child to fully develop in an artificial womb? What will happen when synthetic gametes become available? What about cloning? 20 years ago, that was universally opposed. But what if public opinion has changed? There is no guiding principle or universal truths behind what this legislation would allow going forward. And who knows what route we may end up on. If one would really like to contemplate where this could lead, I would recommend reading Aldous Huxley's Brave New World. Looking at the legislation before us today, I cannot help but think that some of the seemingly prophetic notions in that novel should bring us to a place of caution. Good intentions do not always lead to good outcomes. I could carry on about the glaring holes in this legislation, like the absence of any regulation on the fertility industry, protecting against fraud, or basic criminal screening of intended parents to ensure they're not a danger to children. I will lay to rest my arguments that appeal to one's reason and conclude by shifting my focus toward faith and the metaphysical. I will try to keep my remarks here as short as possible because I can already hear the grumbling that one's faith should not be reflected in this chamber where our laws of civil governance are crafted. I cannot respond with merely worldly arguments to the progressives' left's faith in relativism or their idea to there being no universal truths. We are talking about the creation of life and a created order, and faith is central to that discussion. For someone like myself who ascribes to a conservative philosophy, the real conservative philosophy based on universal truths, not libertarianism or populism, there is a fundamental principle we all share. This is the core principle of belief in a creator. One does not need to adhere to a particular creed necessarily, but they must genuinely believe in a creator and a created order, and that it is the role of us here on earth to subject ourselves to that order. This concept was, by and large, accepted across the American political spectrum until very recently, even in my lifetime. In accepting the idea of a created order, one is also accepting to live life with tension. This is the tension, of course, of trying to align ourselves, reflected in our laws, with that higher order. The tension arises when our own desires conflict with the divine. This tension and our role as civil legislators was best described in 54 BC by Cicero in the work The Republic, which he wrote in exile as the Roman Republic was struggling for its survival. His words here highlight how the laws of nature and nature's God conform with positive civil law. Cicero stated, "True law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. It summons to duty by its commands and averts from wrongdoing by its prohibitions. It does not lay its commands or prohibitions upon good men in vain, although neither have any effect upon the wicked. It is a sin to try and alter this law, nor is it allowable to attempt to repeal a part of it, and it is impossible to abolish it entirely. We cannot be freed from its obligations by Senate or people, and we need not look outside ourselves for an expounder or interpreter of it. And there will not be different laws in Rome or Athens, or different laws now or in the future, but one eternal and unchangeable law will be valid for all nations for all times. And there will be one master and one rule, that is God over us all. For he is the author of this law, its promulgator, and its enforcing judge." Here Cicero is making the case that natural law trumps anything we can attempt to alter here in this chamber. 1,500 years later, St. Thomas Aquinas would expound upon the natural law. It can be a challenge getting people to get excited about the natural law when compared to new progressive ideas. This is difficult because while the left offers something that sounds exciting and controllable, the natural law offers restraint and obedience. If one wants to find their life, they must lose it. If one wants to be a disciple of Christ, they must deny themselves, pick up their cross, and follow. I am no St. Thomas Aquinas. I am not capable of using faith and reason and putting it into any great summa. Some may not agree with the faith or reason arguments behind my opposition to this bill, but the point I wish to make is that it is not my faith or my reasoning. I speak of the truth as it has always been and it always will be. I hope my words here today, at a minimum, can be received with charity, as there is no intent of judgment. I know this is a highly sensitive topic that touches many people very closely. I cannot support this proposal as a whole for a host of reasons that I have laid out at great length. This proposal is riddled not only with practical problems, but also it is a revolutionary departure from the natural order. I encourage my colleagues to vote no.
Further discussion?